In this module, we go into more depth on the term sheet. The term sheet is the single one document in the whole of the process of structuring a private equity deal, which summarizes all the essential elements of the deal. So it will come after the initial contacts are made, before the due diligence starts, and before the final deal. And it acts as a document that will summarize the essential aspects of the deal. So for any person acting as an advisor to a company, a good understanding of how a term sheet is structured is one of the essential elements of understanding private equity deal structuring. And we've dedicated a whole module to the term sheet alone for this very reason. The term sheet is something that would generally be created by the PE fund manager, and therefore it is important for any advisor to the company to be familiar with the term sheet so that they're not intimidated by it, and that they know what to expect in the different clauses, and they are in a position to better advise the company owner as to what aspects of the term sheet are crucial and which ones are less crucial, and in this way they will be able to add a lot of value. It's possible that a legal advisor might be involved with the term sheet, but in many emerging markets countries, legal advisors may have limited experience of private equity term sheets, and that's why, even though a legal advisor may be employed, it is important that the trusted advisor with knowledge of private equity would be the central focus of the negotiation of the term sheet from the point of view of the seller. The objectives of Module 8 are uses of a term sheet and its sequence in the investment process. An illustration example, we work through a sample term sheet and its typical clauses, both the binding and the non-binding aspects. And finally, we cover disputes and litigation in private equity. Uses of a term sheet and sequence in the investment process. Introduction. Private equity deals tend to be complex and require detailed documentation. Parties to an agreement may include one or more PE funds, the target company, shareholders of the company, debt providers. In emerging markets, enforcement issues are even more important. There is a preference in private equity for agreements governing laws to be in jurisdictions which have good knowledge and experience of private equity. Preparation of the documentation. A non-disclosure agreement, known as an NDA, is usually signed up front to protect the parties. Sometimes there's a preliminary letter of interest, or LOI, signed to show a tangible interest and allow the party to have something in writing at an early stage. And legal counsel will be required post the term sheet phase. Documentation sequence. At the deal sourcing phase, a non-disclosure agreement is signed and perhaps a preliminary letter of interest is issued. At the stage of preliminary due diligence and negotiations, the term sheet is signed. During formal due diligence, we would then look at the first drafts of the final closing agreements. In the final negotiation, the sale and purchase agreement and other related agreements would be signed, and at closing, any final documentation and amendments of the corporate articles of association would be executed. Non-disclosure agreement, or NDA, allows for the exchange of confidential information between the parties. In private equity, it tends to be a one-way bias, as the target company does not need much info about the private equity fund. There is usually a clause lifting the secrecy obligations if the information becomes publicly available in some other way. The key negotiating points of an NDA are the term of the agreement, the items covered, and any potential monetary remedies in the event of a breach. NDA obligations may be reconfirmed or amplified by further confidentiality agreements during the deal. They tend to be difficult to enforce unless there is a specific and clamorous breach included. The term sheet. It's also known as a heads of agreement or letter of intent. It's the basic preliminary agreement setting out key terms and modus operandi to closing. It's usually non-binding except for exclusivity and confidentiality clauses. The private equity fund and the seller use the term sheet to make sure there is a general agreement on the terms to be included in the final documentation. The term sheet also allows parties to start regulatory and government approval processes if these are relevant to this transaction. It also allows the parties to approach other finance providers such as banks, mezzanine providers, other co-investing private equity funds, or co-investing LPs. In the term sheet, one area of sensitivity can be that of which party is going to be paying the due diligence and other transaction costs, and this both in the case of a broken deal, in other words a deal that doesn't conclude, or a successful deal. The term sheet can be signed at slightly different points in the transaction. It can be signed at a very early stage or after a little bit of due diligence and negotiation, but not too much. Some of the main items covered in a term sheet will be the amount of the investment, the type of financial instrument, the type of security that will be deployed, and the percentage ownership as a result, what use will be made of the new funds injected into the company, any incentive mechanisms for management, what are the exit agreements for the private equity fund to exit their investments, what are the veto rights that are going to be given to the private equity investor, any changes in management as a condition of the deal, what are going to be the steps to closing, what are going to be the reporting requirements of the company post-investment, what are the costs of due diligence and the confidentiality agreements, and the typical length of a term sheet would be something between 1 and 50 pages, but most typically in between 12 or 25 pages. Question 1. What is the process and documentation sequence in a private equity investment? Please select one answer. A. Preliminary due diligence and negotiation, deal sourcing, formal due diligence, final negotiation and closing. B. Deal sourcing, preliminary due diligence and negotiation, formal due diligence, final negotiation and closing. C. Preliminary due diligence and negotiation, deal sourcing, closing, formal due diligence and final negotiation. We here explain some terms commonly found in specifically venture capital term sheets, so referring to earlier stage companies and startups. Cumulative dividends means that the dividends would not be paid out in cash and would just be rolled up until the exit point. Liquidation preferences means that the preferred shareholder would get first right on the liquidation, and these can be participating, non-participating, and participating. Participating means that the preferred shareholders would get a double benefit of the liquidation preferences. Reverse vesting, this would mean that the founders, the original founders or entrepreneurs, will actually lose their shares if they leave the company. And usually the vesting happens over about 4 years with a cliff arrangement. In other words, the entrepreneurs have to stay for at least 4 years in order not to lose their shares. Anti-dilution, this is a clause that protects the private equity investor in the case there's a further financing round at a lower valuation. Pay to play means that a private equity investor who doesn't participate in a future financing round may get their preference shares downgraded to common shares. Employee pool refers to stock option grants to management. The sale and purchase agreement, also known as the SPA, is the main contract between the private equity fund and the shareholders governing the terms of the transaction. It reflects the key points of the due diligence, the company valuation, the deal pricing, the deal structuring, the future corporate governance, and the exit strategy that has been agreed. 2 stages of the transaction are signing and closing. Most often these are staggered. The acquisition could be structured as a purchase of either equity shares or as assets, and the sale and purchase agreement may be supplemented by a separate shareholders agreement as well. Key provisions of the SPA. Purchase and sale. The private equity fund purchases equity or assets of the target company. The price is specified. The price can be fixed at signing or adjusted at closing. There's usually a long stop date by which the deal must be closed or terminated post-signing. Representations and warranties. Representation is a statement of a fact that is material to the transaction. Warranty is a confirmation that the statement made is true. Remedies for a breach of representations and warranties could be termination of the agreement or damages. Covenants. A covenant is a promise by a party to the agreement to refrain from taking certain actions before and after closing. Affirmative covenant is an action a party is required to take. A negative covenant is an action a party must refrain from. The purpose of pre-closing covenants is to ensure the buyer finds the company in the same condition at closing than at signing. The purpose of post-closing covenant relates to the performance of the target company. In other words, it allocates the risk post-closing. Indemnification. This sets out the monetary remedies protecting a party from losses. It gives certainty of rights and responsibilities in the event of a breach. Escrow accounts can be sometimes used to guarantee payment. Conditions precedent. These are events that must be waived or satisfied for the transaction to proceed. If the condition precedent is not met, the other party can walk away from the transaction. Pre-closing condition precedents are the most commonly found in agreements. These can be company-specific items or they could be regulatory requirements. Material adverse change. The MAC clause allows the buyer to walk away in case of a material event that impairs the value of the company. The MAC clause is used as a catch-all term to cover events not covered by precise specific clauses. The buyer will seek a wide definition to have flexibility. The seller will seek a narrow definition in order to not give the buyer unfettered excuses to leave the deal. Termination rights. These describe the circumstances under which a party may walk away from the transaction post-signing, and it often includes provisions imposing breakup fees on the party terminating the agreement. Debt commitment letter. This is a letter from a bank which is participating typically in a buyout transaction. It will be addressed to the acquisition vehicle arranged by the lead arranger of the debt. It will often be required by the seller before signing to make sure that the buyer has all the funding he needs to proceed with a leveraged buyout. It will be subject to specific closing conditions, such as an execution of a full loan agreement. Equity commitment letter. This will be a letter addressed by the private equity fund to its acquisition vehicle, providing a limited guarantee of equity funding to the vehicle. It also may be a letter from equity co-investors in a club deal used by the lead investors to show that the equity part of the arrangement is fully funded. Escrow agreement. An escrow agreement is a mechanism to enforce claims resulting from a breach of agreements or underperformance based upon a formula. One of the parties, usually the seller, will put funds into an account controlled by a third party whose actions are regulated by the escrow agreement. It is also possible to have shares in an escrow arrangement. The escrow agent will turn over the cash or the shares to the party who can substantiate a claim. Escrow agreements become more important as the jurisdiction is less reliable for enforcement. Bank guarantees can also be a substitute for escrow agreements for some items. Shareholders agreement. An agreement separate from the main SPA between the private equity fund and the selling shareholder. It tends to cover items which are specific to relations and arrangements between shareholders. Examples of this are exit arrangements, put call options, drag and tag along rights. It will control provisions of the investment. It can be more flexible than using articles of association. It covers arrangements relating to adjustments in shareholdings relating to ratchet mechanisms, and it has the advantage of confidentiality as it involves only the shareholders. Buyout debt documentation. In the case of leveraged buyouts, there will also be a debt element to the structure. One will be a loan agreement. This would be an agreement between the debt provider and the leveraged buyout SPV, special purpose vehicle. And this will contain the main terms, the conditions precedent, the covenants, the default events. The other type of debt documentation will be the intercreditor agreements, and this will govern rankings among the different debt providers in a leveraged buyout. The secured lender, the first, second lien, the junior debt holders. It will cover the order of claims, the subordination of the lien, standstill periods, payment blockages, and debt limits. As part of any private equity deal, there'll be a shareholders agreement signed typically, as well as eventual modifications in the Articles of Association of the company. Articles of Association are more regulated by statute and will focus more on economic rights. The shareholders agreements are a private document and will define control and more complicated economic rights. So the AOA would cover shareholder structure, liquidation preference, dividend rights, and the basic rules of the shareholder assembly and the board. The shareholders agreements would cover board arrangements, veto rights, share transfer agreements, and other features such as drag and tag along rights, ratchet, and other arrangements. One of the important points in any private equity agreement is the choice of jurisdiction for the agreements. And in many cases in private equity, this usually ends up being a large developed country jurisdiction. Let me give as an example, if I'm a private equity fund from Spain and I'm negotiating an investment in a company in Belarus, it's very likely the Belarusian company is not going to be comfortable with Spanish law, and it's quite likely that the Spanish company is not going to be comfortable with Belarusian law because neither are familiar with it. And so what tends to happen in international private equity agreements, and many of them are because the private equity funds are usually incorporated in other jurisdictions, is that the parties will decide to choose a jurisdiction with which they are both comfortable or can both accept. And in most cases, in private equity, this will end up being a jurisdiction such as English law or US law, Southern District of Manhattan and others, or perhaps a major European law such as German or French law. In some cases, with smaller deals or very local private equity funds, doing, let's say, for example, a Serbian private equity fund investing in a Serbian company, then it's perfectly expected and possible that Serbian law would come into play. But unless we're talking about a purely domestic investment fund, you should expect that most private equity agreements will be structured under a different jurisdiction than the one of the company in which the company is located, the country in which the company is located. It is possible to have the agreements governed by such a jurisdiction, and the other choice that comes in when it comes to dispute resolution is the choices between using courts or international arbitration. And it's very common in private equity to use international arbitration, but of course the party should seek independent legal advice for a specific deal as to whether the arbitration is the correct choice in terms of it being enforceable, for example. Question 2. Which documents are included in the shareholders' agreements? Please select all relevant answers. A. Board arrangements. B. Share transfer arrangements. C. Veto rights. D. Shareholder structure. Illustration example. We work through a sample term sheet and its typical clauses. Please note that a term sheet includes both binding and non-binding aspects. The first section is investment. 1.1 amount. The total amount which will be invested, both as money out and as money in. We may specify the distinction in this clause. 1.2 valuation. The pre-money and or post-money valuation basis upon which the investment will be made. 1.3 valuation adjustments. In case of any shortfall emerging during subsequent due diligence, this clause deals with an eventual mechanism to adjust the valuation to reflect this. Typically will be a euro for euro adjustment based upon net asset value. 1.4 capitalization table. There will be a table in the appendix showing the ownership structure pre-investment and then post-investment. 1.5 instrument. Specification of the type of financial instrument through which the private equity investment will be made, Example, preferred shares, ordinary shares. 1.6. Timing of investment. When the money will be transferred, any deferred payments will be specified here. 1.7. Use of funds. There will be an appendix table showing in detail how the money in part of the funds will be used. Section 2. Conditions of investment. 2.1. Conditionality. Any conditions for the deal to close. These will either be conditions precedent or conditions antecedent. 2.2. Due diligence. Specification of the type of due diligence which shall be performed on the company prior to closing. The costs of due diligence and which party shall pay for them will also be specified, both in case of a deal completing and in case of a broken deal. 2.3. Co-investment. Specify whether the lead investor will bring in any other private equity funds as co-investors on this deal. 2.4. Share options. Specify whether a share option scheme will be introduced for key managers, employees and/or board members. 2.5. Ratchet mechanism. A ratchet mechanism means that there may be adjustments to the shareholdings linked to the future results of the company. Section 3. Good leaver, bad leaver. 3.1. Good leaver, bad leaver provisions. Specify under which conditions an employee will be considered either a good or bad leaver. This is important for the compensation structure, especially the stock options. One of the main objectives is to protect the company from key staff taking trade secrets to the competition. Section 4. Terms of investments. 4.1. Representations and warranties. Statements made by management regarding the financial condition of the company. List of specific statements. 4.2. Board of Directors. Define the agreed structure of the new Board of Directors, such as how many seats the investor will have, any provision for an independent director. 4.3. Veto rights. A table which specifies a list of decisions which require the approval of a private equity director, even if the private equity fund has a minority stake. This will curtail the power of the majority shareholder. 4.4. Corporate committees. Clause specifying the formation of board subcommittees, such as an audit committee, remuneration committee, hiring committee. 4.5. Managerial appointments. Clause dealing with any changes in management as part of the investment, such as the appointment of a new CFO and the method of selection. 4.6. Reporting. Introduction of auditing and reporting systems in the company post-investment, such as quarterly and monthly reporting. Commitment to implementing an MIS system. 4.7. Share acquisitions. First refusal, drag along, tag along. Deals with future share transactions among the parties to the transaction. Regulates the effects of a party selling or a third party making an offer for shares, relevant to the exit strategy. 4.8. Exit strategy. Agreement as to how the parties will pursue an exit at a future time, may be a structured agreement or a general statement of intent. 4.9. Undertakings. Any other miscellaneous requirements on any other party to the transaction. 4.10. Service agreements. Any requirement that management and key employees enter into proper employment contracts which reflect the transaction and its requirements upon employees. 4.11. Key man. Specification of which employees are considered key men may be a requirement the company take out insurance for them. 4.12. Monitoring fee. Fees charged by the private equity investor for acting as board members, as well as further fees for work done in supporting the company. 4.13. Transaction costs. Specification of who bears which costs. This will include due diligence costs as well as eventual broken deal cost compensation to the private equity investor. Section 5. Confidentiality. 5.1. Confidentiality. Clause specifying that the contents of the term sheet are confidential. This is a binding clause. 5.2. NDA undertaking. Commitment by the company that it will ensure its officers' employees enter into further NDA agreements which will reconfirm and amplify the clause above. Section 6. Applicable law. 6.1. Law. Specification of the jurisdiction whose law shall govern the agreement. 6.2. Dispute resolution. Mechanism for resolution of disputes, typically choice between court or arbitration procedure. Section 7. Expiry date. 7.1. Deadline. There will be a time limit on the validity of the executed term sheet, which will govern the exclusivity period. There may also be a deadline specified for the other party to sign from the moment the PE investor signs, so that the offer is time limited. Section 8. Exclusivity. 8.1. Exclusivity specifies that during the period of the term sheet, the seller may not negotiate with any other party. May also specify that the private equity investor may not negotiate with a direct competitor. 8.2. Breakup fee. Fees payable by the seller in the event of a broken deal. Circumstances under which the breakup takes place are also specified. Section 9. Legal relations. 9.1. No intention to create legal relations. Legal clause amplifying the fact that the term sheet is to be considered non-binding or at least conditional on various other events. Section 10. Exclusions. 10.1. Exclusion of representations and warranties. There may be some items which have been disclosed as items of concern, which are then listed as exclusions from the general blanket statements made in the representation section. Section 11. Model documents. 11.1. Document templates. Parties may agree to base their agreements upon some model documents, such as the British Venture Capital Association or the North American Venture Capital Association templates. This is done to reduce legal fees. Binding versus non-binding term sheets. Typically, term sheets will be non-binding except for cost, exclusivity, and confidentiality clauses. Confidentiality, the parties commit to keep the transaction confidential. Exclusivity, the parties will only negotiate with each other during the specified period. Cost, due diligence and broken fee costs will be binding. As a practical issue, one should be very careful to note that some courts may consider the term sheet a binding agreement in the event that it is very long and detailed. So one has to get legal advice and be careful about the jurisdiction of choice for the agreement. In this section, we consider disputes and litigation in private equity transactions. Litigation in private equity, like in many other areas of financial transactions, is always a last resort and can be difficult and expensive. The two choices are to go to court or to go to arbitration. In the case of a court, it tends to be expensive, it tends to be lengthy. The court may lack knowledge of private equity, depending on the jurisdiction, but the enforcement is usually clear, at least from a domestic point of view, although there may be problems in enforcing the judgment in one jurisdiction into a different one. Arbitration, it's generally cheaper depending on the type of arbitration procedure chosen. The parties are able to influence the choice of the arbitrator, meaning they're able to appoint somebody with expertise in private equity. It's in general faster, but enforcement can be more of a problem than in courts. There can be a problem at the level of exequatur, which refers to the fact we have to take the arbitration, give it a court status. There can be counter arbitration started by the other side to muddy the waters. There can be a nullification proceeding started to set aside the arbitration, which is different from appeal. And we can have non-recognition of the arbitration by certain courts. Here we outline some of the relevant concepts we may find in litigation. These refer to the level of culpability, and we give a description of these. The terms may vary a lot according to the jurisdiction, but we give the terms according to English law, and the advantage of that is that these four terms are clearly legally defined and well understood by the parties. Fraud, a person has acted dishonestly with the intent of making a gain for themselves or anyone else, or inflicting a loss or a risk of a loss on another. Willful misconduct, a person willfully misconducts himself who knows and appreciates that it is wrong conduct on his part in the existing circumstances. Gross negligence, Gross negligence is a conscious and voluntary disregard of the need to use reasonable care, which is likely to cause foreseeable grave injury or harm to persons, property, or both. It is conduct that is extreme when compared with ordinary negligence. Negligence. Simple negligence means negligence which is neither gross nor wanton. It means the failure to use ordinary care. It differs from gross negligence in degree, but not in kind. Some further relevant legal definitions. Exculpation. This is a contractual provision that relieves the party from any liability resulting from a negligent or wrongful act. Indemnification is a contractual provision in which one party agrees to answer for a specific or unspecific liability or harm that the other party may incur. Common arrangements in private equity funds regarding indemnification and exculpation may have an impact on the deal structure, so it's important to understand the presence of these. Internal indemnification, it's a typical provision that the partnership will indemnify the general partner, the manager, their affiliates, the persons involved, for any liabilities incurred in connection with the partnership. External indemnification, this focuses on the relation between the fund and an external service provider. The service provider will not be liable to the partnership or its LPs and will be indemnified to a certain level. Exculpatory clauses, this provides that the GP and its affiliates shall be liable for costs and expenses from mistakes of judgment. The above will generally be tempered by legal restriction on broad hedge clauses and exceptions for willful misconduct or fraud. Working with legal counsel in private equity. It's possible to get to the term sheet stage without using legal counsel if the private equity manager has a sufficient experience and uses a jurisdiction which is familiar to him, such as, for example, English law. Legal counsel, like other service providers, is looking for work and is paid by the hour. Litigation insurance could be an option, but is often available or not cost effective, particularly in private equity. In developing markets, local counsel may lack private equity expertise. And finally, we have the diplomatic issue of engaging with the incapable legal counsel of a seller. So a seller may hire legal counsel who's somebody who knows them, who they're comfortable with, but who has no private equity knowledge and may get in the way of executing a successful deal, and this requires some diplomacy in negotiations.
Question 3. What are arbitration characteristics? Please select all relevant answers. A. Enforcement clear. B. Cheaper depending on procedure. C. Can influence choice of arbitrator. D. Faster in general.
In this exercise, we present the attendees of the course with a blank term sheet, which has already been structured according to the lecture of this module. And we then present you with a situation of a preliminary agreement, and you're required to translate that into a term sheet form. And this is a very useful exercise in terms of deal structuring. So finally, I would like to express my thanks to the World Bank for allowing me to share a version of the course that I developed with them and put it online on my website, on my LinkedIn profile. So thanks for that. Secondly, all the modules, this module and all further modules, will have a certain amount of case studies and additional materials attached to the module, which are part of the learning experience. These materials I will be posting on a specially created group that I have made in LinkedIn called Gavin Ryan PE Course. All you have to do is search Gavin Ryan PE Group, and the group will come up for you to join. You who are following this course, you'll be eligible to join my group and get these additional materials once you've connected to me on LinkedIn and once you've subscribed to my YouTube channel. So when I receive a request to join this group, I will check these two things and then I will admit you to the group. So thank you very much for your attention. I hope you've enjoyed this module and I look forward to seeing you on the next module.